Hey there, legal warriors. In this video, I'm going to cover a new term that I want you to know. The term is the illegal limit, and that's different than the legal limit. That term, the legal limit, will get you in trouble every time. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will see it. More people get the help they need, and actually that's the whole point of this channel, is people getting the help they need. The illegal limit. That's a term that I came up with probably in the last 12 months. And why it was important that I came up with the term the illegal limit is because so many people get in trouble and get a DUI because they think about .08 as the legal limit. So when I hear the term the legal limit's .08, well, naturally, if I'm under .08, I must be legal. And if I'm over .08, I must be illegal. Well, why that is a problem is because people think I'm under .08, I can't be charged with a DUI, right? I'm under the legal limit. And that's just not how it works. So we have to look at the statute. The DUI statute is codified in the Revised Code of Washington. It's RCW 46.61.502. And that statute says, at least for alcohol, there's two different ways that we can be found guilty of DUI. Now, how criminal law works is the legislature writes the crime, and they define it, and then there are elements to the crime that the prosecutor has to prove to have somebody be convicted of the crime. And so the elements of a DUI would be operating a motor vehicle anywhere in Washington State, that even means on private property, believe it or not, while having a breath test that registers .08 or higher within 2 hours of driving for alcohol consumed before driving or while driving, or, so that first way, if you're .08 or higher, breath test for alcohol within 2 hours of driving, for alcohol consumed before or during driving, then you're guilty of DUI if it happened in a motor vehicle, and you were driving, and it was in Washington State. So, well, that means I'm fine if I blow an 06, Lance, right? Because I'm not .08. Well, that's where the second part gets you. The other way you can be found guilty of DUI is if you are under the influence of alcohol. And that is defined basically by other rules to say that your ability to drive is affected in any appreciable degree. So if you blow under the legal limit of .08, you're not off the hook because they can still use the other prong, affected by alcohol, to show that you're guilty. And this is why we don't want you to do field sobriety tests and stuff like that, because when you do the field sobriety test, the rigged game that you cannot pass, stone cold sober, they will not let you pass a field sobriety test because, of course, they already think you're DUI. That's why they're asking you to do it. They're going to use that field sobriety test to show, well, hey, they couldn't walk a line, how could they drive? Then use the fact that you were speeding. Well, it must be because of alcohol. They're going to use the fact you were driving too slow. It must be because of alcohol. Going to use the fact that you were talking fast like me. It must be because of alcohol. You're talking too slow. Must be because of alcohol. So they're going to use all of that. You leaned on the door as you got out. You stumbled. You didn't listen to directions. All these things to show that your ability to drive was affected in any appreciable degree. So why do we care about this word, the legal limit? Because it gets you in trouble. I want you to think about .08 as the illegal limit. If I'm over 08, I'm illegal. I've violated that portion of the statute unless I can claim that it's more than 2 hours after driving, or it's for alcohol consumed after driving, right? I've seen cases where someone crashes their car, they go right into the bar, they start drinking. Now they can't prove what they were before the crash because they're in the bar drinking, right? So I'm not advising you to do that, but I've seen that case. But I want you to think about that .08 as the illegal limit because that's going to help protect you. Well, Lance said that I'm automatically illegal if I'm above an 08. That doesn't mean that I'm legal if I'm below it. So you might blow an 02 and still get charged with DUI, an 03, an 04. How can that be? I'm under the legal limit. Remember, it's not the legal limit. It's the illegal limit. And that's why I want you to think about it, because, of course, I'd rather you not have to hire us or any other law firm to defend a DUI, because it's a really bad thing to have to go through. It's really bad. So let's say you are pulled over for this DUI and you're afraid that you're going to be above the illegal limit. What do you do? Well, most of the time, if I were pulled over, I would not admit to drinking. I would not do field sobriety tests. I would not do a portable breath test. Then if I was taken to the station after I was arrested, I would ask to speak to an attorney. There's going to be a public defender on call. You're going to want to talk to that attorney. And then I would ask for privacy, so the officer is not listening to my conversation, because that on-call public defender is going to have a script they go through. Going to say, why did they stop you? Did you do field sobriety tests? What did you tell them you drank? And then between me and you, what did you drink? How much do you weigh? How tall are you? When was your last drink? And then that public defender, if they're really good, they're going to try to get a guess of where you might be based upon the answers you've given them. And then you can decide, are you going to take that breath test or not? Now, if you're afraid you're going to be over the illegal limit, a lot of people will say, well, then I should just refuse. And that used to be a pretty good strategy back before marijuana DUIs became common. In the old day, before there was a per se limit for marijuana, for THC, which is 5 nanograms in a blood draw, it was sort of a pain in the butt for police officers to apply for a search warrant and track down a search warrant to get your blood, right? But because of marijuana DUIs necessarily require a search warrant to get blood for marijuana, there's no other way to prove you guilty, at least of the per se version of the marijuana DUI law. Now it's just sort of, check a box and hit a button. It's very easy for them to get a warrant to seize your blood if you refuse the breath test. So that's usually going to make it worse, right? If you have a refusal, there's worse penalties. It doubles your minimum jail time. It doubles your conviction suspension. It's 4 times the administrative suspension. It goes from 90 days to a year suspension. And so that the big risk we could take in the past by refusing the breath test and hope they didn't do anything and they have no numbers at all, and hey, I didn't do the field test, where's their evidence? It's pretty much out the window, because almost always they're going to get a blood draw now. And the secret problem with that also, it really delays the start of your case. If they, when you get pulled over for a DUI, you sort of don't want it hanging over your head forever. We don't want to deal with it, but we want to get it behind us. Well, on a breath test case, it may get started pretty quickly. On a blood draw case, it's going to take at least a year in most cases for those results to come back from the state toxicologist. So you might if you got a DUI in March of 2025 and it's a blood draw, you might not be in court until 2027, okay? Again, your mileage may vary based upon the court, but that's a very common outcome. So, obviously, easiest thing to do is not drink and drive, not use marijuana and drive. But if we do get pulled over, what I would do is not give them additional evidence. I would talk to that on-call attorney and then try to make a reasoned decision, should you take the breath test or shouldn't you? And then, of course, once you get out of police custody in this situation, you want to remember we've got, in most cases, 7 days to request a licensing hearing, depending on what the result of your breath test was, or it was a refusal. And we also then need to contact an attorney right away, because there's so many variables that can't be covered on the internet, on Google, on this video, but can be covered by a thinking, knowing lawyer that has a lot of experience in whatever area you are where you got pulled over. So remember, the illegal limit. Once we're above it, we're guilty according to the law. Once we're under it, that doesn't mean we're not guilty. It just means they have to try to use all that other evidence that they want to try to get from us to show we're guilty, even if we're under that number. So hopefully you found this useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.